Hi, it's Jessica again. We're in week 2. Let's refresh what we learned from chapter 1. We learned 6 basic requirements to form a valid contract. We looked at some definitions of those requirements. The hardest thing, the thing that people struggle with the most usually, is that unilateral versus bilateral thing. And hopefully you can understand that if the offeror is seeking a promise, they actually want somebody to promise them something, then that's going to be a bilateral contract. If they just want them to show up and do the act, and in the event they show up and do the act, they get the money, that is the much narrower situation of the unilateral contract. So about 97% of all contracts are bilateral. Most people want promises in exchange for promises, but sometimes they're just willing to allow the act itself to be both the acceptance and the performance at the same time. Either now or when you get done with this video, go to the polls under communication and take the poll on bilateral versus unilateral K. K is the shorthand for contract. In this chapter, you'll learn the definition of an offer, the essential terms of an offer. An offer is the first essential element of a contract. This is the definition of an offer: a proposal by one party who gets called the offeror, with an OR, to another party, the offeree, that manifests an intent to enter into a valid contract. The book talks about 3 common law conditions for a proposal to qualify as a contractual offer, and that's right in the book. Now, the reason that common law is specified particularly is because common law is different than the UCC, which we'll talk about later. So the first of the 3 common law elements is there present contractual intent? This is not a black and white question, and it does take all circumstances into consideration, and it uses the objective test, a reasonable person objectively. Is it clear that the offeror actually intended to make an offer? I've got the Pepsi Harrier Jet case as a sample for you of where the judge at least believes that it was not clear that the Pepsi intended to offer a Harrier jet for Pepsi points. Why don't you go right now to the link to the YouTube Pepsi Harrier jet advertisement, and then we'll talk about that case for a minute. I'm assuming you went and watched the video for the Leonard versus PepsiCo case. It's a commercial that Pepsi put out that suggested, somewhat jokingly, some would argue, that you could purchase a Harrier jet for 7 million Pepsi points. A gentleman from Seattle decided to sue PepsiCo. He actually put together a package of 7 million Pepsi points by giving them a check. He paid 10 cents a point for most of the points, and then he paid a $10 shipping and handling fee, and he wanted his Pepsi Harrier jet. The court ultimately found that the advertisement featuring the jet did not constitute an offer. There were a couple different rationales for this, but one of the reasons the court said there was no offer is because advertisements in general are not considered offers. But even beyond that, the court said no reasonable person could have believed that the company seriously intended to convey a jet worth roughly $23 million for $700,000. That, i.e., that it was mere puffery. Puffery is the idea that a company is allowed to say fuzzy, nice things about its products as long as they're not too concrete and objectifiably false. What I want you to do is to, after you've watched the video and you've read my recapture of some Wikipedia information about the case, I'd like you to go to this PDF link in this slide, and basically you can Google Leonard v. PepsiCo decision, or Kimba Wood decision in Leonard v. PepsiCo, and you'll find the case. What you're looking for is the trial court's decision. I'd like you to read that trial court's decision and then answer the poll question that's listed under Communicate. It's listed under Course News and Events. It's one of the 2 polls that are listed there. I want to survey the class and find out who all agrees with Judge Wood about the issue. In any event, it's clear that the judge said the advertisement was not an offer. And again, what if I said, I'll sell my sister to you for $25? The question would be, is that a valid offer? And the answer is probably no. An objective, reasonable person would imagine that that was actually a joke. These things are always evaluated under the circumstances of the offer at issue. So, under these traditional common law statements, I should say the traditional common law criteria for an offer, one of them is it has to be communicated to the offeree. Communication of a valid offer creates power in the offeree to accept and create a binding contract. One of the classic examples in this area is an offer to pay somebody a reward for finding, say, a dog that somebody doesn't see. So it's never actually accepted. They bring the dog back. The ad is not a binding offer. The person who made the offer does not have to pay the offeree because there was no valid offer. It wasn't communicated to the offeree. So if we're sitting at court and I whisper to you, my opposing counsel, that I'd like to make a settlement proposal, even though it's whispered, it's still intentional. That's still a communication to the offeree. But contrast that with muttering under your breath. That's not intentionally something that is going to the offeree, so that would not count. Courts have held that posting on the church door is communicated to the offeree. Posting in Craigslist, as long as it meets the other criteria, may be sufficient. But let's query whether you place something in a bottle and throw it overboard. In that situation, you don't know who the offeree is going to be, and it's unlikely that that would be held to be communicated to the offeree effectively. This slide deals with the issue that Kimba Wood talked about regarding the Pepsi Harrier Jet case. This is an old issue in contract law. And under the traditional common law rules, ads in papers are merely invitations to negotiate, not offers themselves. In other words, they're a pre-offer. They're just a request to enter into a negotiation, which may or may not result in an offer. So let's look at this first case. You can see the link to that if you'd like. There was a gentleman who was the first to respond to an ad that said, and it was in the 50s, one mink stole for the first customer who was in line at 9 a.m. at our store at, let's just say, 123 Broadway. That individual was denied the mink stole because in the 1950s because he was a man and he shouldn't be wearing a mink stole. Let's just say he wanted it for his own personal use and the store denied him that. So he sued. And in that particular case, because the ad was so precise, it was held to be a binding offer. But generally speaking, when you see an ad in the paper for Macy's or for Home Depot or whatever, those are not considered binding ads under traditional contract law. Now, they may be binding under Federal Trade Commission rules, that is, agencies who actually hold sellers to their written promises, but under traditional contract law, an ad alone, unless it's super specific, like the one in the mink stole case, is not going to be sufficient to constitute an offer. The third one is the offer certain and definite? Let's take a look at these examples. Someday I'll sell you my law practice. Is that an offer somebody can sue on? No, because it's too imprecise as to the someday. If that were narrowed down and given more specific, then perhaps it could constitute an offer that could be accepted and that would form the basis of a mutual agreement and that could be sued upon. I will babysit your child for you. Well, it doesn't say when, it doesn't say how much. It's just a general invitation to negotiate. It's a pre-offer. I offer to share my controlling interest in this company to any taker. Well, the problem is money is not specified here, and as we'll see below, money is often a required element. For $5, I would sell my sister. Again, that's probably going to be considered not objectively reasonable as an offer, and it would not qualify as a certain indefinite offer. According to the common law, there are four essential elements for definite and certain terms in an offer. You've got to check and see, is the price there? Is the subject matter there? Are the parties there? Is the time of performance clear? Uh, Many of these can be what we call gap filled under the UCC if they happen to apply to the sale of goods, because the UCC is a statute that it's actually a model law that applies to the sale of goods. So if it's the sale of goods, the rules are different. But under the common law, you have to have all four of these things for it to be a certain and definite offer. So the court will consider this on a spectrum, and sometimes, even under the common law, can gap fill with the idea of reasonableness. However, the bottom line is a court will not create a contract where there was no mutual assent. That's under the common law. Under the UCC, which deals with the sale of goods, there are two doctrines that allow people to gap fill. The court will actually look to see what is their course of dealing, that is, how have they dealt with each other in the past. The other one is the course of performance, which is how have they dealt with each other after the deal was made. If something is ambiguous and the parties mean different things, no contract was actually formed. The two ships Peerless case is a very old, famous old case in which there were two ships named Peerless that happened to go different places at different times. Both parties contracted thinking that they were dealing with one Peerless ship, but in fact they meant the other. One party meant the other. So they had two different ideas in their mind. So therefore no mutual assent ever was reached and no contract was formed. They had the appearance of a contract, but there was so much ambiguity that was actually mutual that there was no contract, no mutual agreement. If something is really ambiguous and it's actually too vague, an example of that would be an offer leaving total discretion to one party. For example, I'll buy your doll collection for a price that I think is fair, or I'd like to consider buying your seafood business. Those two are void for vagueness as too ambiguous. However, I will buy your ranch for market value tomorrow is objectively determinable and so therefore is sufficient and is not void for vagueness. Here's a potential test question. What is an output contract? It is a contract that specifies that the buyer will purchase everything the seller makes. What is a requirement contract? That is, the buyer specifies they will buy everything they need for their business from the seller and the seller only. Those are two different things that have similar ideas, and because they're determined by an objective standard, they're not considered vague. Just briefly about the Uniform Commercial Code, it was a model law that has now been enacted by each state in whole or in part statutorily. So if you want to find out what Washington's UCC law says, you have to look that up specifically. But it's dealing with the sale of goods. That's kind of its own category. If it's the sale of goods, you've got to look to the UCC for the law that pertains there. And we'll track both the common law and the UCC in this class. And here's a link to the UCC. Okay, I'm trying to keep these as short as possible to keep your attention, and so I'm signing out for week 2. Take a look at Angel and see all the things you've got to do. I hope you're having fun, because I am. Take care.